Okay, perfect. All right. Hello and welcome everyone to today's webinar. This is our Legal Issues for Associations webinar brought to you courtesy of our brilliant legal mind here, Jim Goldberg. Jim Goldberg, or James, as he's formally known, is a principal in the Washington, D.C. law firm of Goldberg and Associates, PLLC, and serves as an outside counsel to ACRO. His practice focuses on the representation of nonprofits, trade associations, professional societies, foundations, and other types of tax-exempt organizations in all aspects of their operations, including taxation, employment law, and contract issues. Mr. Goldberg is a former chairman of the Subcommittee on Trade Associations within the American Bar Association section on business law, and formerly served on the Governing Council of the American Society of Association Executives Legal Section. Mr. Goldberg is an active member of the Tax-Exempt Organization Committee of the District of Columbia Bar. He serves on the Board of Directors of the Academy of Hospitality Industry Attorneys. So now that the introduction's out of the way, I just want to do a quick note on logistics here. We are going to open this up to you to join the actual phone line, and as soon as I'm done talking, I'll actually type that information in there. I do ask that when you are not speaking or trying to ask a question that you keep your phone muted so you don't interrupt Jim while he's talking. If you do want to speak, I ask that you raise your hand using the raise hand function in the webinar. Near the top of it, you'll see a little figure with this hand raised. Once you raise that, I'll acknowledge you and just find a good stopping point for Jim, and then I'll address you directly so you can ask the question. If you prefer not to ask it over the phone, you can obviously use the chat window at the bottom there, and Jim will address it as soon as he reaches a good point to stop. And so now that that's out of the way, without further ado, Jim, you can take it away.
Thanks, Mike, and welcome to all of those who have joined the call this afternoon. This is pretty much an annual presentation that I do to state and regional organizations under ACRO. And some of you may have heard this before, and if you have, I apologize for the repetition. What we're going to cover today are some legal issues for associations, including structure, a little bit of taxation, some issues about contracts and intellectual property. So let's delve right in. The first question to ask yourself is, are you incorporated? What kind of organizational structure do you maintain? The last time I checked, ACRO had about 37 state and regional organizations. There were 24 that were incorporated that I could find and 13 unincorporated. Now, I, like most lawyers, will recommend incorporation because it's a way of limiting or eliminating liability for the directors and officers of a state or regional organization. It sets up a liability shield between the organization and the individual directors. So the first question to ask is, are you incorporated? If you're not and are thinking about it, the process is generally pretty easy. Many states allow incorporation to be done online, and if it's not actually done online, they will provide sample forms for you to fill in and use to be mailed in to the appropriate address. It's important to have some legal advice if you do incorporate, if you're not already incorporated and you do decide to incorporate, because the state forms for incorporation do not include what I call the magic words that the IRS requires in order to obtain a tax-exempt status. So while you can do this yourself, it's a good idea to have some advice from somebody who's knowledgeable in the nonprofit corporation law of the state in which you operate. Whether you're incorporated or not, it's important to maintain corporate or organizational formalities. First question to ask is, if you're incorporated, you have to have a registered agent. Registered agent is either an individual or a corporation who is designated by the organization as a formal contact by state government, and in the event that anybody wants to sue the organization, you do so by serving papers on the registered agent. It's important to understand who your registered agent is, because in volunteer-operated organizations that use individuals, which is fine, sometimes these individuals leave their jobs, move to another locality, drop out of the profession, and therefore notices go into a black hole. They're sent to somebody who is no longer serving as a registered agent. I recommend that you use an individual where it's feasible, because using a corporation to do it will incur a fee, and sometimes it's just not worth it. The next question to ask is, who files required state reports? Every state requires corporate entities to file periodic reports as to their status, listing the registered agent, listing the individual directors. In most cases, these state reports are required annually, but for example, in the District of Columbia, it's a biennial basis, which is every other year. In Texas, it's what the law calls a periodic report, which is some vague standard every, not more than often than once every 4 years, and you get a notice from the state that it's time to file, which makes it difficult to maintain a calendar as to when these reports are due. If your reports are not filed on time, you can file them after the fact, but typically there's a late charge. And if it goes too long after the due date, the state will actually cancel your corporate charter and eliminate your corporate status, and then you have to start the process of bringing all your reports back up to date. We found one state that, although they're in compliance now, they were revoked for a period of about 5 years before they got right with the state. And then the next question to ask is, are your bylaws current? And put another way, do you do what the bylaws say? Bylaws are like a roadmap for operating an organization. As most of you know, they set forth the rules of governance, how many directors, how the directors are elected or appointed, terms of office, and the like. But if they're not looked at for a period of time, there's a tendency for some organizations to change practices without changing bylaws. So the question to ask is, are we doing what the bylaws say we're supposed to do? And if not, do we need to change what we're doing, or do we need to change the bylaws? I recommend that you take a look at your bylaws at least once every 2 years, just to make sure you're on track for doing what you're supposed to be doing. And then the big issue, as far as I'm concerned, which I've called do unto others. Because in a volunteer-led group, people come and go. You're on the board of directors for a short period of time. You may be president or chairman of the board for a year, maybe 2, and then the gavel passes to the next person. I recommend that every organization that's run by volunteers maintain what I call a corporate record book or file. It doesn't have to be hard copy. It can be an electronic file, but it should have the organization's articles of incorporation, because they set forth, like the Constitution of the United States, they set forth the overall framework under which the organization operates. The corporate record book should contain the organization's current bylaws, and it's always a good idea to put the date that the bylaws were last amended on the document, so you know whether it's the most recent one or not. The corporate record book file ought to maintain a record of the organization's federal employer identification number, which is the federal tax ID number. Any tax exemption determination letter that you received from the IRS, copies of state annual report filings, and the name and address of registered agent, so that this information gets passed down from leadership to leadership, and hopefully nothing drops between the cracks. After you maintain the corporate formalities, you have to ask yourself the question about are you tax exempt? And every one of you is eligible to be a tax exempt organization. You can be tax exempt under what's called 501c3, which is educational organizations. You can be tax exempt under 501c6, which are promotion of a line of business like a chamber of commerce and some professional societies. The difference is somewhat negligible, but if you're not tax exempt, you obviously have to file your net income as a corporate taxpayer, and you could be liable for federal and perhaps state income tax, which gets to the issue, which loops back to the issue of your federal employer identification number. Is that number issued in the name of the state or regional organization, or is it issued in the name of somebody else and you're operating under their auspices, if you will? In order to get a tax-exempt status, you must affirmatively file with the Internal Revenue Service. In some cases, you file with the state as well. The process is either very simple or very complex, depending on whether you're a 501c3 or a 501c6 organization, and secondarily, what you anticipate your gross revenue is for the first 3 years of organization. If your gross revenue is estimated to be under $50,000, and that's total revenue from all sources, not just dues, but meetings, bake sales, sales of publications, whatever, total revenue of $50,000 or less, you can obtain a tax exemption by using what's called a Form 1023-EZ, which is a one-page, very simple form to file, and you usually get notification from the IRS within 30 to 60 days, if not less, depending on what time of year you file. So having determined whether your organization is tax exempt or not, then one goes to required tax filings. And the form that you have to use is dependent upon what the gross receipts of the organization are. And again, gross receipts are not just dues income, but total income taken in from conference registration, from sale of publications, from services rendered and the like. What's the total income of the organization? If it's under $50,000, you file something called a Form 990N, which is commonly referred to as the e-postcard because it's done online only. If you don't file within 3 years, for a period of 3 years, the IRS will automatically revoke your tax-exempt status, and you have to go back to square one and start all over. If you have gross receipts between $50,000 and $200,000, which is, I think, where many of you may fall, you get your tax exemption by using a Form 990-EZ, and then if you're over $200,000, you file a Form 990, which I would suggest you have a knowledgeable accountant file because that can be somewhat complex. Are there any questions thus far as to corporate formalities or tax filings?
As a reminder, if you do want to speak over the conference line, feel free to raise your hand and I'll make sure you get addressed.
Okay, I'll just move on in case some of you have come up with some questions. If we've already covered that part, we'll go back and deal with it. Some additional tips. If you pay individuals more than $600 a year for services rendered, maybe you have somebody who works at a conference, is a paid contractor who works at a conference for you, and that person gets more than $600 in a calendar year for doing this work. You have to file a Form 1099 for the payments to those individuals, which means you need to know their name, address, and social security number for filing the 1099 forms, which I think are due the end of January of the subsequent year. So if you have anybody who has worked for you in 2018 for whom a 1099 needs to be filed, you better start looking into it, because those are due at the end of January in 2019. And then ask the question, do you have insurance? There are essentially two types of insurance that you need to be considered. One is what's called commercial general liability, which is the business version of a homeowner's policy. So if you have a conference in a venue and somebody slips and falls on a banana peel and injures themselves and you get sued, that's where commercial general liability insurance comes into play. And many hotels, most hotels at which you hold meetings, require that the sponsoring organization maintain insurance. This is the kind that you would maintain. Commercial general liability insurance, in my experience, is generally pretty reasonable. You can get $1 million worth of coverage for anywhere from $350 to $500 a year, and that's a minimum premium. So it's fairly reasonable as insurance payments go. You might want to consider, depending on the organization, officers and directors insurance, often called association professional liability. And this protects the organization in case its officers and directors do something illegal or something else that they shouldn't do, like unfairly discipline a member, or not admit a member who should be a member because of discriminatory reasons. D&O policies are fairly expensive, and they can run as the minimum premium that I've seen recently is about $2,000, $2,500 a year. So it's not for everybody, but it's something that's worth looking into to see whether it's necessary or desirable, depending on what your activities are. I see that one question has popped up here about does the 1099 requirement apply to stipends or honoraria too? And the answer is yes. Any payment to individuals that exceeds $600 requires, as I understand it, a 1099 form, which is the functional equivalent of a W-2 form, which those of us who work on salary get at the end of a year. Was there another question, Mike, that popped up in the chat box that I didn't?
Yes, so there are two other questions. One from Rebecca. She writes, I wonder if we can learn a bit more about why we might be a C3 versus a C6. This is a question we often ask.
Well, the differences, let me take a couple of minutes and try to discuss the differences. A C3 organization is for educational, charitable, and scientific organizations, like the colleges and universities that all of you work for. A C6 is like a trade association. The differences are that payments to a C3 can be deducted as charitable contributions. Dues payments to C3 organizations are eligible with some limitation to be deducted as charitable contributions. So if your members are paying their dues out of their own pocket, that might be a reason to go with C3. A C6 payments are not deductible as a charitable contribution. They are, however, deductible as an ordinary business expense, which, as I understand the way the tax law has changed, is not a deduction that's available for most people anymore. The other differences are C6s can engage in virtually unlimited federal lobbying. C3s are limited to a certain amount of money that can be spent on lobbying at the federal level. The other major difference is that some states, many states but not all, allow C3s to be exempt from paying sales taxes on the products and services they buy, so that if you're a C3 organization and have a conference at a hotel, the meals that are purchased by the organization, the group meals that are purchased by the organization, may be exempt from state sales tax on meals served. Given the kind of membership that a state ACRO has, I think it's possible to qualify either under one or the other category. It's just a question of how you structure your articles of incorporation and bylaws. If you already have a tax exempt under C6, I would not go back and try and change it to a C3. If you haven't considered a tax exemption and want to start from scratch, I'd consider doing a C3 because it's, I think, more beneficial to more organizations. Rebecca, does that answer your question?
She writes, why not change?
You're considering changing to a C3. I think it's doable. You're going to have to file a new tax exemption application. You're going to have to make sure that your articles of incorporation and bylaws contain the required C3 provisions in the IRS code, but it's something that I think is worth considering. I don't have a feeling one way or the other as to whether it's a good idea or a bad idea, because every organization operates in a different way and has a different reason for considering the change. And the question is it worth the aggravation of trying to make the change and the upfront cost of trying to do that? Let me go on to another issue, and then we can loop back for questions. One of the other problem areas that volunteer-managed organizations often run into is the signing of contracts. And it's important to understand that when you enter into a contract, the title of the thing that you're signing, and there ought to be a signed document. Legally, a contract does not have to be in writing to be binding. The issue, of course, if it isn't in writing, how do you prove what the parties agreed to? But frequently, organizations that are volunteer-run are somewhat hesitant to enter into quote-unquote contracts, but they're okay with entering into agreements or memorandums of understanding or letters of intent. The title of what you sign or enter into is not important. It's the content of the document that makes it a contract or not. So regardless of the title, you may be entering into a binding document, binding relationship with the other side. All you need to have a legally binding contract is an offer by one party, an acceptance of that offer by another party, and what's called consideration, which is typically the payment of money. So hotels, for example, in order not to try and scare user groups away, will call their contracts letters of agreement or event sales agreement, but it's still a contract and it still binds the organization. If you have one of these documents, the obvious first question is, do you understand what you're signing? And sometimes there are provisions that are obviously written by lawyers and frankly are unintelligible even to people like myself. So you need to ask questions like, what does this mean? And if particularly from a hotel, if you get an answer that says, I don't know either, it's something our legal department requires, I would get another set of eyes to take a look at what you're signing, because that's a big red flag that what you're signing may be significant. When you have a contract, particularly for conferences at hotels, you ought to keep track of relevant dates, because there are certain dates in these contracts where you can cancel without liability, you can cancel with limited liability. You have to provide information about your rooming list or your attendance list. Some contracts, like for web hosting or other services, have an automatic renewal unless one party or the other gives notice 60 days or 90 days or 6 months before the end of the contract period that it's not going to be renewing. So it's a good idea to keep a sort of a running calendar that says, for example, by December 31st I have to do thus and such. By February 15th we have to do thus and such. By June 15th we have to do something else. And then the question of who maintains copies of these agreements, which ought to be a part of the corporate record book file that gets passed from leadership to leadership, and more significantly, who signs the document, who has authority within the organization to sign and bind the organization. I would suggest that it be very limited. Don't let too many people sign contracts on behalf of the organization, and make sure that everybody knows what they have a right to do or not do, so that you don't have somebody who doesn't really have authority to sign a contract enter into one, and that ends up binding the organization and causing a problem. And then lastly, what I wanted to touch on was the subject of intellectual property. Intellectual property is a very valuable form of asset, and there are three kinds that we worry about in the association community. One is a trademark, which identifies the source of a product or service. It's a way of identifying, for example, ACRO with its logo or its publication titles, so that nobody else can infringe on a word or a phrase or a logo that the organization has protected. Trademarks are valid for an indefinite period of time as long as they're continued to be used. Obtaining one costs about $375 initially. One can do it online, but there are some nuances that typically require some assistance. But it's a way to keep to protect against somebody coming in and poaching off your name. A copyright, on the other hand, protects works of authorship, like material that's posted on listservs, and like the speeches that are made by speakers at a conference. If I make a speech at a conference, I have a copyright interest in my speech, and you are not entitled to record me, archive my speech, archive my handouts or my PowerPoint, unless I have given you permission to do so. So it's a good rule of thumb to get a release from all speakers as a matter of routine, whether they're members of your organization or not, in which they grant you permission to do whatever with their presentation, record it, archive it, post it on your website, whatever. Sometimes you'll run into a professional speaker who's a paid speaker who will not give you permission, but that's important to know that as well. And then finally, in the area of trade secrets, protecting your members' names and addresses and contact information is important not only for possible identity theft or data breach purposes, but just so the members won't be harassed by other parties. There are hotel room, commonly referred to as poachers out there, who will somehow get a hold of membership mailing lists and contact members and say they are the authorized room provider for a particular conference, and try to steer members into booking hotel rooms through them rather than, say, directly with the hotel. The best way to protect that information is put it behind a firewall and make sure it's only accessible by actual members who have a user ID and password. And that, in about 30 minutes, is a summary of major legal issues for associations. We have some time left, so I'd be happy to take any questions that may have arisen. I know we've kind of flown through this, but let's see if we have any questions as to what we've covered to date.
Yeah, sure. So one we had a little bit earlier from Audrey Crawford was, who do most organizations use to be responsible for filing taxes and keeping paperwork up to date for tax-exempt status?
Depending on the size of the organization, I think most are using CPAs, accountants who are knowledgeable in tax-exempt organizations.
I would imagine that's helpful just because those individuals typically don't change and they know what they're doing.
Yeah, yes.
And any other questions, feel free to write in or speak up over the conference line. And Jim, we'll give it a few minutes here, and if it does seem as though the questions have dried up, then we'll just end it a little bit early.
Okay.
As an aside, this webinar has been recorded, so I'll send that link out to everybody afterwards, and we'll update the actual webinar page on the ACRO website. So when you click, you can just view a recording of this instead if you need to reference it at a later point.
Well, I would say if you have any questions that arise after you hang up from this webinar, I've put my contact information on the last slide. You can either contact me directly or send an email to Mike at ACRO, and he'll get it to me, and we'll get you an answer.
Does look like a couple people are typing questions in, so I'll hold up on that for a second. We did briefly discuss insurance while during the course of this presentation, and I just wanted to give people a heads up that we last year had attempted to kind of collect a sort of guiding set of documents for insurance, and with the result of that search is basically that it's pretty flexible. You know, I would contact, if you need some resources, you can obviously come to ACRO and we can refer who we use, but you can always look at alternatives. And as Jim had mentioned, it's typically very affordable in terms of premiums to get the kind of minimum coverage that you would need. Going beyond that, we are also, the board of directors has made a work group. Actually, they made it a few months ago, but their charge is to kind of collect a how to run a state and regional organization. So mostly a resource for incoming presidents, treasurers, other board members, or executive committee members. The timeline on when that should be released is potentially by the 2019 annual meeting in Los Angeles, but we'll keep you up to date on that. All right. Well, I don't know if those extra questions are actually going to come through here, Jim. So if anybody does have those questions, feel free to email me directly, and I'll pass those along to Jim, or you can email Jim, and we'd be happy to kind of answer those or guide you as we can. But otherwise, we hope you all have a good set of holidays. This will likely be our last webinar of 2018, so thanks for joining us, everybody. And thank you for presenting, Jim.
Okay, thanks, Mike, and happy holidays to everybody on the call.